Good afternoon, everybody.
We'll start the press conference and turn this over to Josh Tardy.
Thank you, Brian Loco. Good afternoon. This is Josh Tardy, and I hope everyone can hear me. I'm an attorney at the Bangor firm of Rudman Winchell. This morning, Rudman Winchell, as local counsel with attorney Lee Goodman and his firm of Wiley Ryan, a Washington, D.C.-based firm, filed on behalf of certain citizens of the 2nd Congressional District a federal lawsuit that is challenging testing the constitutionality of ranked choice voting. Attorney Goodman has extensive election law experience. He was appointed by President Barack Obama to the Federal Election Commission, where he served as chair, and he is here today to answer any specific questions about the lawsuit. And unless there are questions specific to me, I will turn it over to the attorney.
Well, welcome everyone. Today, several voters of the 2nd Congressional District filed a federal lawsuit to vindicate the constitutionality of their franchise and to challenge the diminution of voting rights under a system called ranked choice voting enacted in the state of Maine that actually thwarts majority will and actually disenfranchises voters and denies them the knowledge of who they are voting for when they cast a ballot. We also contend in this lawsuit that the voters of the 2nd District have chosen their member of Congress in the first count in which Bruce Poliquin won the election by a plurality of votes. The Constitution of the United States provides that the members of Congress shall be chosen by the people in their state or their district. At least one federal court has interpreted chosen by the people to mean a plurality vote. And therefore, the Constitution of the United States recognizes the election of members of Congress by a plurality vote, and we believe Bruce Poliquin was chosen by the people of the 2nd District and is entitled to be certified the winner and to serve the people of the 2nd District in Congress for another term. In addition to that, all of the voters of Maine and the voters in the 2nd Congressional District deserve to vote and to cast their votes in a system where their votes can be cast knowledgeably and effectively. And what the ranked choice voting or instant runoff voting system does is it denies each voter at the time they cast a ballot any knowledge of who the ultimate two candidates will be and the matchup of those actual candidates so that they can make a knowledgeable vote. Voters are required in Maine under ranked choice voting to vote in the dark. And finally, we believe that the ranked choice voting system elevates some votes and voter preferences over others. It gives some voters multiple bites at the apple and elevates or amplifies certain voters by giving them additional choices, and that is a fundamental problem under the Equal Protection Clause of the United States Constitution. Now, being a citizen and voting and exercising your franchise are profoundly important roles of every citizen, and the Constitution protects the profound right of the franchise, and any diminution of the right of the franchise and the right to cast a knowledgeable and effective vote is a very serious issue. We believe we are right in our constitutional arguments, and we hope that a federal court will vindicate our arguments and agree with us. So, in this civil society, what we do is we seek a declaration of those constitutional rights in a federal court. And we are seeking a declaration of the constitutional rights of all Maine citizens before there is a second tabulation or a second determination under the ranked choice voting system. And we hope to do so orderly. We hope to do so with dignity to all of the citizens of Maine. And we hope that a declaration of constitutional rights will give everyone comfort and confidence in the results of the election that was held 2 weeks ago. I'll take any questions.
Sir, why not do this before the election?
Before the election, you do not know that the ranked choice voting system is going going to take effect or be implemented. You don't know that going in. That's one of the problems with the voting on a multi-choice ballot to begin with. You're not sure when you walk in that ballot place that ranked choice voting is even going to be invoked.
And you're asking a judge what?
We're asking the judge to declare Bruce Poliquin the winner of the election under Article 1, Section 2 of the Constitution. Secondly, we are asking a federal judge to rule that the ranked choice voting system in Maine is unconstitutional, and therefore the election was determined by the vote, the plurality majority vote on November the 6th, and to declare Bruce Poliquin the elected congressman for the 2nd Congressional District.
And the options the judge has before him at this point are what?
Well, right now we have requests for relief, and our relief is as I just explained it to you. We are asking for a declaration of law, and we are asking for the court to set things right under the Constitution, which would result in Bruce Poliquin being certified the winner of the 2nd Congressional District election. Now, whether or not the state has other options for the court, such as denying our relief altogether, that will be up to a federal judge. And we want to give a federal judge time to reflect on this and issue us a reflective ruling.
So just to clarify, the options that you'd like to see, you laid out, but the options that exist for the judge are more than what you're asking.
Could be, for one thing, a judge could federal courts, both a federal district court judge and or the First Circuit U.S. Court of Appeals could disagree with our arguments and approve of ranked choice voting as a constitutional matter, in which case at least everyone in Maine would have certainty that they are participating in a democratic election that is constitutional. And by the way, even if we lose this lawsuit, that is of benefit to all Maine voters because this was the first general election where ranked choice voting was used in Maine. So we believe there are wholly salutary purposes for a federal court to rule on this before there is a retabulation and another certification of a different winner. We think that everyone will benefit from having a federal court look at this system and determine if it is constitutional.
So, and I don't mean to jeopardize, but the potential exists that tomorrow the button will be pushed for the tabulation on the second round. What is the likelihood that a judge will issue a preliminary injunction before that button is pushed?
Unlikely. We, earlier today, we sent a letter to the Secretary of State and the Attorney General of the state, requesting them not to tabulate the votes and not to determine a second winner under the ranked choice voting system until all of us, including the Secretary of State, would have the benefit of a federal judge's ruling on whether it is even constitutional. We believe that to respect the people of Maine, we ought to wait until a federal court has given us that declaration. So far, we've been told that the Secretary of State does not plan on ceasing the counting at least, and therefore, if we need to today, we will file a motion for a temporary restraining order on an emergency basis in order to preserve the status quo. And that means to preserve the constitutional rights at stake that would be harmed by finalizing a retabulation.
So you have a few hours to decide whether you're going to go forward seeking a TRO. What is the likelihood that you will do that?
We're in consultation on that right now, and I think that if the Secretary of State continues to move toward a tabulation of the votes, then we may have to seek the extraordinary relief.
Do you have a close of business deadline for that, or is that something you can seek after the normal business hours?
We could. I think it would be more efficient if we let the federal judge know that we were come in before the close of business. I'd like even the judge to get home for dinner tonight.
Again, I apologize.
You're fine. Was this the plan all along then to seek a lawsuit if it went to ranked choice voting?
I cannot say that that was always in the plan. You know, you wait sometimes until you have an actual case in controversy, and sometimes, indeed, in some of the cases where courts have reviewed ranked choice voting in other states like Minnesota, in some cases, people bring these lawsuits too soon, and they're told, they're told, wait a minute, we don't have an actual dispute in an election. It's not being implemented in the particular election, and nobody knows what its impact is going to be or whether it will even be invoked. And so sometimes plaintiffs are told, you're here too soon and you're on too theoretical grounds. So we had to wait until we knew for certain that ranked choice voting would actually be triggered and implemented in this election in order to have a ripe controversy.
Did some of,
In the case Phillips versus Rockefeller, rejected a push that the language in Article 1, Section 2 called for a majority in the state that used a plurality system, but it didn't dictate that the legislature couldn't require a majority to determine the will of the people.
Yes, except that in that Second Circuit decision which we rely upon, the court did not reach a conflict. What the court said was that New York had not adopted a absolute majority system. And therefore the court never had to reach the conflict between what Article 1, Section 2 means, which is plurality, and what the result would have been had New York actually enacted a law that countermanded that plurality. But it is very hard to conceive of a provision of the Constitution that means plurality, and then, which is of constitutional import, and then to grant a state a right to countermand what that provision means, which is that plurality is sufficient. In other words, whether a state can go beyond the plurality that is currently provided for in Article 1, Section 2 is an open question. The Supreme Court has never been decided.
some of the plaintiffs, if I recall correctly, some of the plaintiffs chose not to participate in the second and third choices on their ballot. They just voted for their first choice. Is that correct?
Yes.
That gives the impression that they were gearing up for this eventuality. Is that a fair statement?
Honestly, I don't believe that any of my clients were voting in preparation to be plaintiffs. I believe everybody was hoping that we would never reach this point, but we did reach this point. And now all voters of Maine, by the way, my clients are individual citizens of the 2nd Congressional District. They stand in the same shoes as every citizen in this district. And they are seeking a declaration of constitutional right to vindicate the constitutional rights of all citizens, because all of the citizens of the 2nd District of Maine, regardless of which outcome you actually prefer, deserve the right to have their franchise protected and to vote in an election that is implemented in a constitutional manner. And that's what our federal lawsuit seeks to declare. Whether or not this election has been conducted and whether or not each voter's franchise has been respected in a constitutional system.
Is Representative Poliquin also a party to the lawsuit?
He is. He is a plaintiff because he is a voter in the district. He is also the candidate directly affected by the vote counting system that is approved.
We have additional questions that are in the queue from people on the conference line. May we start taking those now?
We may.
Sure. Okay. For folks that are listening on the conference line, if you have a question, please push *3, that's the asterisk button and the number 3 on your telephone keypad. If you have a question, please push *3, the asterisk button and the number 3 on your telephone keypad. I believe this first one is from the Bangor Daily News. You should be live. Please go ahead.
Hey, Brent. Mike Shepard from the Bangor Daily News. Lee, I was just wondering, it seems like your argument on voter information sort of cuts both ways. It stands to reason that some of these independents could have voted differently if, they knew their ranked choice votes weren't being counted. So I was just wondering, what do you think about that?
Well, Mike, let me give you a hypothetical. What if on every ballot, in every election, I put 10 names on a ballot for you, and I told you 2 of these 10 people are actual candidates in contention? You have to guess at the 2 candidates, at the 2 names on this list who are actual candidates in contention, and then you have to tell me which one you prefer out of these 10 names. And that denies you the right at the assume that was the ballot you were actually given by a state. I don't think anyone would argue that that is an appropriate way to run an election, or that it is fair to any voter to make them guess at the actual 2 candidates of a list of names. And that is what happens here in the runoff aspect of this election. When because at the time you cast your initial vote here, you have to guess, and this is inherent in the ranked choice voting system, you have to guess at the last two candidates who will actually be in contention, and you have to rank your votes today based on that a matchup of candidates that you have to guess at. So let me give you this this example. I may prefer candidate A over B. If I know that there is an election between A and B, I can express and vote knowledgeably and effectively my preference for A over B. If it's B versus C, I may vote B over C. I prefer B's qualifications over C. But if you give me the matchup between A and C, it's not necessarily so that I will vote for A. I might vote for C over A. You can imagine a real world situation. I might prefer in a Republican primary Trump as to Bush. I might, in the matchup, if the matchup is going to be Bush versus Rubio, I might prefer Bush. But then when I get to the matchup between Trump and Rubio, maybe I like Rubio better than Trump. Every voter in Maine in the federal election on November 6, 2016 was denied the right to make that kind of knowledgeable choice at the moment they mark their ballots. And we contend that is a fundamental debasement of the right to cast an effective and knowledgeable vote. And so that is the heart of this constitutional challenge.
We have another question or comment now, I believe from WCSH. Please go ahead.
Hi, this is Don Kerrigan from WCSH TV. The Constitution doesn't specifically talk about plurality, does it, Mr. Goodman?
The Constitution in Article 1, Section 2 provides that members of Congress shall be those chosen by the people in their district. The U.S. Court of Appeals for the Second Circuit, which covers New York, had occasion to define what chosen by the people means under Article 1, Section 2 in a 1970 case involving Nelson Rockefeller. And the U.S. Court of Appeals for the Second Circuit says for 140 plus years, chosen by the people has meant a plurality of the vote. Now the question we raise is, can the state of Maine alter or raise the standard set as interpreted by the Second Circuit? So we will be asking a federal court here in Maine whether he agrees with the Second Circuit Court of Appeals that chosen by the people indeed means a plurality vote, and then secondly, can Maine alter that standard?
We have another question or comment now, I believe from Maine Today Media. Please go ahead.
Yeah, hi, this is Kevin Miller with the Portland Press Herald. So going back to your timing of filing the lawsuit, you said that could not be filed before the election because you didn't know whether the ranked choice system would be implemented. However, it was obvious that ranked choice was being used because voters were going into the polling booth and using the ranked choice system to choose how to vote. So how are you not able to challenge it back then?
Well, the system wasn't being implemented at that point. We didn't know what the vote count was. Now we know what the vote count is. We know that the state is proceeding with making a second count, that is effectively conducting a virtual runoff election on those existing ballots. And so we have and we know that neither candidate got 50% of the vote, which triggered this ranked choice voting's application in this election. So we know now for certain that the system is being implemented. And so we have chosen to bring this lawsuit at a time when we knew it could impact the outcome. It could actually infringe constitutional rights. And we brought the lawsuit before the Secretary of State has completed a recount and a runoff count and a tabulation or certification of a different winner, so we think we're timely.
I believe we have a follow-up question from WCSH, Josh and Lee. Is that good with you?
Yes.
That's fine, sure, Brian.
Please go ahead.
Thank you, Don.
WCSH.
Thank you, Don Kerrigan again from WCSH. Mr. Guzman, I presume you were involved, you had been brought into this prior to the election itself when we're already doing that work. How long have you been looking into this matter, and were you brought in by the Poliquin campaign?
That's privileged information. I don't think that's relevant to the purpose of this press conference and me explaining to you the nature of our lawsuit. Next question.
There's nobody else in line in the queue within the phone system to ask a question.
Any other questions in the room?